Good morning to one and all legal fraternity. Now we are going to share legal research methodology with relevant tools of study on medical negligence litigations. Before that, going inside the medical negligence litigations legal research methodology, um, it's our accountability to refer the quotes of the Aristotle. One important point was noticed and explained by Aristotle. He calls attention to the fact that legal rules are necessarily general, while the circumstances of every case are particular, and that it is beyond the power of human insight and science to lay down in advance rules which will fit all future variations and complications of practice. Therefore, a law must be supplemented by equity. There must be a power of adaptation and a flexible treatment, sometimes suggesting decisions which will be add variance with the formerly recognized law, and it will turn out to be instinctually just. With the thoughts of the Aristotle, we are going inside the legal research methodology on medical negligence litigations. Uh, we very well know about the physician's prayer internationally, such as follows. Dear Lord, thou great physician, I kneel before thee, since every good and perfect gift must come from thee. I pray, give skill to my hands, clear vision to my mind, kindness and sympathy to my heart, give singleness of purpose, strength to lift at least a part of the burden of my suffering fellow men and a true realization of the privilege that is mine. Take from my heart all guile and worldliness, that with the simple faith of a child I rely on thee. Relevant to that, based on that, Indian Medical Association prayer also I narrated, such as follows. May everybody be happy. May every one of us see to it that nobody suffers from any pain or sorrow. I don't ask for crown, nor I wish to be in heaven or reborn. I only want to alleviate the suffering of those people who are burning in fire of sorrow. This kind of medical jurisprudence oaths are undertaken by the uh, physicians or the medical professionals. Um, ab initio, if they are following their oaths of the medical jurisprudence prayer, uh, there is no uh, toughest job in the avoiding the medical negligence litigations. So now we are going to introduction about the legal research methodology with the tools and study regarding medical negligence litigations. The Consumer Protection Act 1986 has caused a lot of awareness among the public, and cases against the doctors under the Consumer Protection Act started from early 90s. This created a steep increase in the professional indemnity cases against the doctors. The verdict of the Supreme Court of India, delivered on 13th November 1995, including the medical profession in the ambit of the Consumer Protection Act 1986, increased the litigation against the doctors. So it is the cause of action for the medical negligence litigations origin. The Consumer Protection Act is an easily accessible law for the consumers, and there is no stamp duty involved, unlike cases in civil courts. There is no screening of cases before they are taken up by the consumer forums, and they don't require advocates to argue the cases. The cases are settled very fast and very little expenses is involved. Even if it is proved that the case is a frivolous one, the maximum compensation award against the complainant is only rupees 10,000 under section 26 of Consumer Protection Act. Unfortunately, this has given rise to a lot of frivolous cases being filed against doctors. The problems were compounded due to the inability of the doctors to maintain proper treatment records, and a few cases were lost even though there were no negligence on the part of the doctors. So educating the doctors in the preventive aspect of litigation is essential for practicing the profession of medicine confidently and without fear. This is the spirit of my knowledge sharing. Once again, I repeat, educating the doctors in the preventive aspect of the litigation is essential for practicing the profession of medicine confidently and without fear. What is medical negligence or malpractice? We can assume that medical negligence or malpractice is defined as lack of reasonable care and skill or willful negligence on the part of a doctor in the treatment of a patient whereby the health or the life of the patient is endangered. It can also be defined as a breach of a duty caused by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something that a prudent and reasonable man would not do. These are the definition given for the medical negligence or malpractice litigations origin. Constituents of negligence. Constituents of negligence. Number one, a legal duty to exercise due care on the part of the doctor. Number two, breach of the said duty. Number three, consequential damage. Damage here means infringement. Number four, damage which is both casually connected with such breach of duty and recognized by the law. Standard of care is the standard of the ordinary skilled man exercising a professing to have that special skill at that particular time. A man need not possess the highest expert skill. It is well established law that it is sufficient if he exercises the ordinary skill of an ordinary competent man exercising that particular art. He is not negligent if he has acted in accordance with the practice accepted as proper by the responsible body of medical practitioners skilled in that particular art. This is the ingredients given for the the constituents given for the negligence. Now we are going to share causes of litigation. General causes. Number one, death during or after treatment or operation. This is one of the commonest cause of medical negligence litigation. The death of a patient who is no seriously ill or who comes for an uncomplicated surgery is quite unexpected. The relatives feel that there is negligence on the part of the doctors who treated the patient. Number two, failure to get proper consent. Many hospitals get blanket consents from the patients for invasive procedures. Nothing is mentioned about the failure rate or the complications or about alternative medicine of treatment. So when litigation is initiated against the doctor, the importance, irrespective of facts, the longer they are neglected. This develops into an official complaint with the time. Following are the faults of dealing with the complaints. Following are the faults in dealing with the complaints. Number one, not listening to the complainant. Number two, not clarifying the complainant. Number one, not listening to the complainant. Number two, not clarifying the complaint. Number three, getting bogged down in trivial. Number four, neglecting to explain why and how. Number five, putting the blame on others. Six, apologizing too soon without realizing that there is no fault. Apologizing too soon without realizing that there is no fault. Then ignoring the complaint. Then absolute denial without finding the true facts. At last, trying to cover up even when there is fault on the part of the hospital staff. These are the following of common faults occurs during the dealing in the complainants. Next one is inadequacies in the hospital. Many hospitals try to treat the patient without sufficient leading to problems. When a complication occurs, this is sufficient ground for litigation. Once again, I repeat it. Inadequacies in the hospital. Many hospitals try to treat the patient without sufficient leading to problems. When a complication occurs, this is sufficient ground for medical negligence litigation. Unwanted comments by colleagues. It is said that for every case filed against a doctor, there is another doctor behind it. When there is a failure to adhere to the professional ethics by a doctor in making unfavorable comments about the treatment of the professional colleague, the patients or the relatives take advantage of it. So next we are going to share causes according to specialties. The main cause of litigation involving various specialties are given below. Number one, in obstetrics and gynecology, a large number of cases in O&G department were those involving failure of sterilization surgery. The recent verdict of the Supreme Court, wherein it is mentioned that doctors are liable to compensate the patient if they become pregnant after sterilization surgery. It is highly likely that more compensation cases will be filed. Other causes included failure of MTP, stillbirth, and inquiry to the newborn, injury to the newborn body, birth asphyxia, and subsequent complications of the newborn, complications following normal deliveries and surgery, bleeding after delivery, delay in conducting cesarean operation, complication of ectopic pregnancy, death following jaundice in pregnancy, which carries a high mortality, and failure of the obstetrician to attend to the labor in time. This is the main cause of litigation involving the obstetrics and gynecological specialties. In surgery department, most of the cases involving surgery were arising out of the complications following surgical procedures. Other causes included wrong diagnosis, unnecessary surgery, and a delay in doing surgery leading to complications. Most of the cases involving surgery were arising out of the complications following the surgical post-operative post-surgical complications. Other causes included wrong diagnosis, unnecessary surgery, and delay in doing surgery leading to complications. In the field of orthopedics, the cases involving orthopedics were confined to non-union, malunion, and delayed union of fractures. The patients expect a pre-fracture state after treatment, which is not always possible. In general medicine specialties, most of the cases were due to wrong or late diagnosis, misleading information, wrong treatment, drug reaction, prescription of drugs which were contradicted, and failure to rise to the expectation of the patient concerning a fast recovery. In ophthalmology specialty, infection following cataract surgery formed the bulk of the cases against ophthalmologists. Other cases were those involving complications of surgery like displaced IOL, retired detachment, delay in detecting um, penetrated foreign body, delay in diagnosing glaucoma, and wrong prescription of glasses. In the anesthesia specialty, the cases against anesthesiologists were revolving around complications following general anesthesia and spinal anesthesia. In pediatrics specialization, most of the cases were involving mismanagement of diarrheal disease, irrational treatment, prescribing drugs which were contraindicated, delay in diagnosis of serious illnesses like sepsis, meningitis, and jaundice of newborn. In ENT specialties, complications following surgery were the most common causes of litigation against the ENT surgeons. In urology department, complications following invasive and non-invasive surgeries and failure in the expected results of the various procedures are the causes of cases against the urologists. In general practice disciplinary, wrong or delayed diagnosis and treatment formed the bulk of cases against the general practitioners. Failure to refer the patient in time to the specialist was another cause for the litigation against them. In psychiatric specialization, cases involving the psychiatrists were cases regarding allegation about wrong confinement in the hospital and wrong diagnosis and unnecessary treatment and complications caused by drugs. In dermatology specialization, the cases revolved around unsatisfactory results of treatment, which are not a rare occurrence in certain skin conditions. In neurosurgery specialization, complications following surgery and unsatisfactory results were the causes of litigation against the neurosurgeons. In plastic surgery specialization, failure to come up to the expectation of the patient after surgery was the commonest cause of litigation in plastic surgery. The patient usually undergoes plastic surgery with high hopes. The results may not be always up to the expectation of the patient. In ultrasonography specialization, diagnostic error was the reason for cases against ultrasonologists. In cardiology specialization, wrong diagnosis and management were the causes of the cases against cardiologists. In pathology specialization, error in determining the blood group leading to complications was the cause of litigation. In thoracic surgery specialties, postponing the surgery due to the inadequate ventilation was the cause of the case against the thoracic surgeons. In others medical disciplinaries, specialty disciplinaries, they include the causes which occurred due to alleged improper behavior on the part of the staff of the hospitals. Now we are going to share Dealing with a complaint. While dealing with a complaint, the following points have to be kept in mind. Number one, treat every complaint seriously, however trivial the complaint is. Per personable appearance is necessary. Be accessible. While dealing with a complaint, the following points have to be kept in mind. Number one, treat every complaint seriously. However trivial the complaint is, personable appearance is necessary. Be accessible. Number two, complaints may be expressed in a fiery, abusive language. Never be rude in return. Rudeness is unprofessional conduct. Keep calm, listen with friendliness, tolerance, and compassion. Number three, if the complaint is true and damaging, the error has to be corrected immediately. Number four, if it is false and damaging, explain the actual facts and convince the patient. Number five, treat every complaint as an emergency. The patient should be informed that a progress report on the complaint will be given at the specific time. Number six, never argue in the beginning. Avoid it. Tell the patient that the complaint will be inquired into fully. Number seven, listen to the patient. Alternatively, make him talk, ask questions, clarifications, and summarize the complaint. Number eight, a doctor should investigate the complaint to the best of his ability. Question others and analyze the cause of the complaint. Number nine, if the doctor or the staff is wrong, admit it and explain in simple, understandable terms. Number 10, if the complaint is not directly the doctor's responsibility, say so. A doctor should tell the patient that he will find out who is responsible and report back. He also should thank the patient for bringing the problem to his notice. Number 11, the patient's right to complain should be accepted. If possible, see the patient with the hospital administrator. Number 12, never put a stigma over the patient for having made a complaint. Ensure that the patient is not labeled as a non-cooperative. Still now we have discussed about the how to deal with a complaint. Next we are going to share how to reply to a notice. Number 1, answer only the relevant points. Number 2, avoid unnecessary commitments. Number 3, avoid scientific terms and abbreviations. Number 4, deny each allegation separately. We have come to a conclusion for the introduction of medical negligence cases. A review of the statistics and the cases shows that there is a steep increase in the number of cases against doctors after the introduction of Consumer Protection Act. This is due to the fact that filing a case in consumer forum is very easy, but this has caused a lot of frivolous cases being filed against the doctors, even though most of the cases are being won by doctors. They are put to a lot of hardships in defending the cases. A lot of time and money are wasted in fighting the cases. They are also forced to practice defensive medicine, ultimately resulting in more harm to the public. Most of the cases lost by the doctors were due to the fact that there was poor documentation and consent forms. Poor consent form. They have no they have to keep proper records of the patients and get appropriate consent from the patients before any invasive procedures. However, the silver lining in the cloud is that the number of cases against the doctors in Kerala has come down in the last 1 year due to the doctors winning a lot of cases as a result of uniting effort of this awareness about medical negligence litigations. Um, Now we are going to share which are the alarming situations. There are certain situations which may alert one to a possibility of a medical negligence suit. Some of the common situations are such as follows. Number one, patient or relatives express dissatisfaction. Number two, asking to take second opinion. Number three, asking to shift the patient. Number four, complication or unexpected result. Number five, death of young patient. 6. Request for medical record. 7. Failure of patient to keep scheduled follow-up. 9. Age, younger age group. 10. Education, highly educated or illiterate. 10. Social service class. 11. Economical, practically no bar. These are the defense uh, common sense applications needed to avoid the medical negligence privilege litigations. Now we are going to share some do's and don'ts or other tools of studies regarding uh, medical regarding medical negligence cases. Um, For the general practitioners, I simply tell the terms as a simple term, do's and don'ts for general practitioners to avoid medical negligence litigations. So, do's and don'ts for general practitioners. Definition: a general practitioner is a basic graduate of medicine, surgery, and OG. He treats pediatric to geriatric cases, maintaining close like with the family physician role. His consultation room should be neat, sterile, comfortable, and quiet. First point. Second point, separate waiting room for patients. 3. Basic amenities. 4. Emergency drugs to include ISO, RDIL, or disprin, oxygen, and Ambivac. 5. Sterile instruments separate for septic and aseptic procedures. 6. Staff, trained staff, well-mannered staff, competent staff, and compassionate staff. These are the team ergonomics should be available in the consulting room in general practitioners. Patient examination, complete history. Number one, complete history. Listen patiently. Number two, more time with patients, less time with the lawyer. This is the well settled principle. If the health professionals spend more time with patients, they will spend less time with the lawyer. Then, free, frank discussion, complete clinical examination, ladies in presence of lady assistant. In general practitioners, negligence, how to avoid. Don't miss cross findings. Fracture, patellar, examine with the consent of the patient. Thorough examination, even repeatedly, if inconclusive, is significant. Next one is call for investigations. Next one is if examined old lady, back pain, casual examination, repeatedly, collapsed spine is negligence. So next we are going to share diagnosis made after careful examination will not be negligence. Diagnosis made after careful examination will not be negligence. Negligence or injury during examination. Example, old man, neck shoulder pain. Examination on couch. While getting down, injured wrist fracture. Doctor fined for not assisting patient. Negligence in diagnosis. How Wrong diagnosis is not negligence, it is only error of judgment if complete examination is done. Wrong diagnosis without complete examination is negligence. Wrong diagnosis of cancer is negligence. Unusual signs, symptoms leading to wrong diagnosis is not negligence. Wrong diagnosis if patient does not reveal truth is not negligence. Delayed diagnosis leading to injury is negligence if proved. Right diagnosis followed by wrong treatment is negligence. In emergency, diagnosis may not be possible and depends on post-mortem reports, not negligence. Investigations vital to avoid negligence. Call for relevant investigations to confirm diagnosis. Diagnosis confirms test biopsy. Yet, if patient does not improve, doctor is not liable. But if the last biopsy are not considered before diagnosis, negligence will be proved. Treatment. Discuss disease treatment options with patients' relatives involving them. Discuss complication whatever possible. Use approved protocols. Use antibiotics judiciously and wherever necessary. Unreasonable delay in treatment is negligence, but due to medical reasons is not negligence. Negligence in treatment. Unreasonable delay in treatment is negligence. Unreasonable delay in treatment is negligence, but when due to medical reasons is not negligence. Due to medical reasons is not negligence. Prescriptions, do's and don'ts. It is most common weapon for treating any patient, at the same time most neglected. It is unethical to put an advertisement on the prescription. Don't prescribe without seeing patient. It is documentary evidence. Medicines prescribed or the departure can be proved. Even the wrong operation can be proved. Complete, neat, legible prescriptions should be maintained. Clear dosage instructions. Call for drugs. Identify and verify them for patients clearly. Inform possible side effects if any. Use familiar drugs as far as possible. Look for expiry date, impurities, floating objects. Note important details on reverse, example ECG, BP, temperature, patient response, diagnosis, and review time. Mention allergies, avoid allergy drugs, example sulfa, penicillin, analgin, etc. Prescription, the documentary evidence. Doctor to doctor. Maintain good cordial relationship with colleagues. Behave with colleagues as you would expect them to behave with you. Avoid criticism in presence of patients. Lapses, if may be personally informed in friendly manner. Don't entice patients from your colleagues. In case of recurrent irritant from colleagues, despite tactful communication, inform association. So, doctor to state how should be maintained. Records, maintain proper records. Family cards, OP cards include allergic manifestations. Then mention all instruction given. Patient response. Consent whatever necessary to be recorded. Refusal to be mentioned. Reference made to be recorded. Time and date. Investigations advised are done actually to be recorded. Receipts to be issued whenever necessary. Records are vital evidence. A proper record saves us during litigations. Avoid false receipts or inflated receipts. Avoid altering records. Courts generally believe in doctors' records if they appear genuine. Don't create records afterwards. Remember, your record is your best friend and best defense in court. Maintain properly and honestly. Tips for crisis. Skill. Exhibit sufficient skill, particularly in complicated cases. CME programs. Regular update with recent developments. Preserve basics. referral, consult or refer to specialist at right time. Advise hospitalization whenever necessary. Next, we are going to share death and adversities during treatment. Deal tactfully and symptomatically. Avoid bitterness. Reveal that you have done your maximum. Preferable for relatives to be present during treatment. Request for postmortem. MLC inform police. Medical legal cases. Inform MLC case should be filed in hospitals. Inform police. Contact district coordinator for that. Medical certificates. What are the do's should be done in a medical certificates to avoid the medical negligence? Please keep complete medical record of history, clinical notes, diagnosis, investigations if any, and treatment of your patients. Next one is please write date, nature, and duration of illness clearly in the certificate. Please examine the patient properly before issuing the certificate. Please note that illness certificate is different from fitness certificate. Then it is advisable to issue these certificates separately. Performa of both certificates is available with government departments. Fitness certificate should be issued by a doctor who has issued illness certificate. Charges should be mentioned clearly and correctly if required. Write your registration number clearly. Inform police in case of accidents, medical legal cases, dog bite, snake bite cases. Keep clinical records of such cases. Do attend courts if summoned. Tubectomy, vasectomy or MTP certificates issued only by the authorized doctors. Now we are going to what are the don'ts in issuing medical certificates. Don't give certificate to a patient who has not been treated by you. Second, don't give certificate unless the patient puts his signature or left hand thumb impression on the certificate issued by you. Don't give certificate to a patient suffering from a communicable disease unless you have notified concerned authority and diagnosis confirmed. Don't give fitness certificate to a patient who has been given illness certificate by another doctor. Don't give certificate to TB, leprosy or mentally ill patients unless diagnosis is confirmed by specialists or supported by investigations. Don't give operation certificate unless you have operated the patient. Don't issue death certificate unless the disease is under your treatment at least 14 days prior to his death. Don't give death certificate unless you have personally confirmed the death. Don't issue death certificate if you have any doubt regarding cause of death even if patient is under your treatment. Don't issue false receipts of fees received. So death certificates issue in proper format. Don't collect fees. Don't give death certificate if homicide or suicide is suspected because they are MLC case, medical legal case. Normal death. Relatives themselves can declare by obtaining forms from the burial ground. Medical legal cases give emergency treatment, inform police, refer as soon as possible, note time and date, maintain records. These are the golden rules in medical legal cases for the health professionals. Give emergency treatment, inform to police, refer as soon as possible, note time and date, maintain records. Fees. You can display your fees in the waiting room or in the consultation room. Doctor can refuse to treat the patient who has defaulted in paying fee. However, in emergency he is bound to treat him. Doctor have a right to claim their fees. Dealing with HIV patients. Health professionals should exercise caution. Testing for HIV. Pre-test counseling is vital. If positive, reveal only after post-test counseling. Maintain confidentiality. Instruments sterilize with a concentrated Lysol. Personal protection. gloves, face mask are dispose syringes, etc. properly. Needle cutter destroy needle and syringes after soaking in calcium carbonate solution or bleaching powder. On biomedical waste, proper uh, incinerations or deep burial. Health professionals should protect your professional ethic practice. It is set less complaints against government practitioners because he has good and direct relationship with patients, pays proper attendance, and refers in time. More importantly, his mistakes are not easily recognized and difficult to prove. And general medical practitioners, regarding general medical medicine practitioners, it is said less medical negligence complaints are very less because general medical practitioners has good and direct relationship with patients, pays proper attendance, and refers in time. More importantly, general practitioners mistakes are not easily recognized and difficult to prove. So we go discussed shared some do's and don'ts to avoid medical negligence litigations for the health professionals, especially general physicians. Uh, During this time, I want to share some academic points based on the medical jurisprudence and the uh, criminal procedure code and IPC and evidence site based. Uh, Normally, the general physicians um, should have the attitude, should have the spirit regarding the world, childhood memory, uh, what has broken the centuries old trust, what has made it worse, cough, fault line, etc. The world. Um, Healing comes from the old English word Helen. Healing comes from the old English word Helen, Haelen, Helen, which means to make or to become whole. Doctor is derived from Latin word meaning teacher. Once again, repeat as per the medical jurisprudence. Healing comes from the old English word Haelen, Helen, which means to make whole or to become whole. Next one is doctor is derived from the Latin word meaning teacher. The words patient and patient derived from the same Latin root meaning to suffer. What is the drug you use in your medical practice all the time? The question posed by a psychiatrist used to baffle many doctors in London in the 60s. The doctor is the drug. And Dr. Michael Blynt would supply the answer to a puzzled doctor. So this is the spirit of the medical jurisprudence. What is the drug you use in your medical practice all the time? If it is a question, um, Dr. Michael Belynt has delivered wonderful answer. The doctor is the competent drug. A childhood memory. I used to hear a popular saying as a child, half the problem goes away when you see a doctor, and the remaining half goes away when you take the medicine. The four imponderables of healing: one, hope; number two, faith; number three, compassion; and number fourth is empathy. It is said by, according to Philip Timothy. What has been broken the centuries old trust? There has been a revolutionary transformation in the medical marketplace, resulting in the dramatic shift in the way we interact and view ourselves in relation to our patients. The helping relationship has been replaced with a contractual relationship. Instead of doctor and patient, it is now provider and consumer. What has made it worse? The media have not been particularly kind to the physician. Perhaps it is anti-authority inclination. Perhaps it's a bit of racking. Doctors are not above being questioned, nor should they be immune to legitimate challenges. But the challenge often takes sorry, the, the form of attack. Articles such as what your doctor never learned in medical school about the undermine farmer trust. Thank you.